by you. You can't rely on
These documents are in their possession, my lord. These documents are in their possession, my lord.
And if you have discharged your liability in 1996, what were you doing for recovery of those documents? The first, anybody does it, take back the original papers. Why were you waiting?
What did you do? What did you do to seek recovery of documents?
My lord.
Such a heavy loan, 34 lakh, 24,000.
हमारा जगह ही
You
उतना ही
keep
लगेगा।
sitting.
Principal amount is only 11 lakhs, my lord. The principal amount is only 11 lakhs.
According to you, you have just paid. So for many years, their money they are giving you.
We don't think it's a case for interference, counsel. And in any case, your delay of 1,360 days beautifully silent. So that's the first thing you have addressed this court on. You're straight on merits. What happened?
My lord, my inspection, he said, serious things. Said 2 times, 4 times, he's struggling with post-COVID ailment.
And merits both. Next.
Obliged.
My lord, page B of synopsis. I am filing this.
Once there is a settlement, there is a question of your coming back to this court, to the NCDR at all.
My lord, that settlement was done under coercion.
Sorry, we are not impressed by that statement.
And that was recorded.
Coercion doesn't impress us.
It was
to say.
recorded in the various orders.
What did you do after coercion? Did you file a police complaint?
Yes, my lord.
Date of the coercion, so-called coercion?
Yes.
And date of the complaint?
Date of the complaint was in 1990.
And date of coercion? When did you
August
sign the
20,
document?
August 2020.
2020. And when did you make a complaint about your purported coercion?
On the next day itself, I made a complaint
So
to the
the
police
criminal,
station.
what is the status of that?
That has not been entertained, my lord.
Mr. Counsel, you are missing two very vital points.
I have not been able to.
No.
I have not been.
Hear my colleague.
Nothing. Just listen to the query of the court.
Yes.
Rather, I am telling you what you should told. After
My lord, I am not able to present.
1 minute. Hear my colleague. You're appearing in person, so be patient.
I'm sorry.
In August 2020, you made the settlement. Why did you wait for 2 months and got the execution deed executed? First. Second, then after that, why did you after 3 months withdraw the petition? So why did you take those 3 steps if you are not able to? And that itself should have said that, Lord, why did you agree to the deed of
Page number 308, they have sent an email to obtain possession. After one,
why did you get the sale deed
After 1
executed in your
month,
favor
What made you
and
sign
after
the sale?
3 months and after 3 months you withdraw?
my lord, I am not
What
able.
is this?
I am not able to present the thing. If you have
Yeah, sir.
Sorry.
amicus curiae.
You ask for appearance in person. We are not going to do.
My lord, I have also mentioned that I am ready to accept if any advocate is assigned.
Your readiness, we are not to test. You are somebody who can afford to engage a lawyer. You want to engage, it's okay. We don't want an amicus.
My lord, I have
Request to engage a lawyer, that's for you to do.
Why am I
I am an unemployed person. I am not able to run my family.
Then argue yourself.
59 lakhs you pay to take a flat and you don't have 2,000.
My lord, I please grant me one date, my lord.
Permission be granted.
My lord, please permit me one date for amicus curiae.
Sorry, we are not appointing an amicus.
Amicus, yeah, we don't need assistance.
You don't want. You are good enough for us. Argue where you know the fact because then anybody.
Yes, my lord.
So explain, how did you
But the
execute?
settlement.
How did you execute the sale deed? Come back to the thing. You thought you got
My lord, I was interested in taking possession of
You want both.
Yes.
You want both. You want
And
both.
after 3 months of that, you withdrew the. Why did you withdraw them?
My lord, they gave me false assurances.
Sorry.
Now coercion, now false assurance, now your desire. It doesn't tally count.
Sorry, dismiss. Next. Yes, four.
Well, the question of the amount is not big, but the question is that in
That also. Right.
yes, my lord, that is in that the petition is section 24 of HMA, where the husband and wife, if anybody have not unable to maintain or carry out the proceedings of the divorce, then only the maintenance be granted in section 20.
Not go on that technicality.
Dismissed. All for your child. Condone the delay in filing.
Please.
I'm seeing you pass.
Awesome.
this is a case where the respondent has concealed the fact of his first marriage and gotten married to this lady. After getting married, after a few months, he enters into an agreement with her where he provides her maintenance and she is living with her parents. After that, he discloses the fact that she is married before and that he has a child. She says that she's going to file a criminal complaint. So he goes and gets married to her again. A criminal complaint is
Void marriage, you know that.
it's a very marriage project. But
Then how do we?
his state, what he does is he files a suit to get this agreement declared as void. Now, in that, his prayer agreement was he put into this agreement a coercion. There is a specific finding by the civil judge that there was no coercion because the criminal.
No, let us understand.
After that,
Let us understand. You married him.
yes,
After that, you had a settlement agreement between.
an agreement for maintenance.
And after that, you again married. Why again married? If the marriage was not nullified, why would you be married?
But only with the consent of this first wife. But
Can it make a difference?
No,
not
you
at all. But
marry
say-
twice. Can you marry twice?
that
marriage-
marriage is inconsequential here. Because the first marriage was there. There is an admission on this part that there is.
Question of any maintenance to you when you cannot be treated as a duly legally married.
May I just explain?
That's what
the reason. Just a minute, and I leave it to you about this. Just 1 minute. His suit was on the ground that she forced him to sign this agreement. There is a finding that there is no coercion.
Right.
Subsequently, in appeal, the first appellate court holds that because it's a void marriage and contrary to policy, this agreement cannot be enforced. With greatest respect, this is contrary to public
No,
policy.
counsel, no. Counsel, we may just observe that probably you took the wrong direction. You should have just filed a suit that since you have cohabited, you have a right for maintenance from him.
You didn't do
It's
that.
better, you didn't do that. You chose to prove him that no, I was correct, legally correct. You should have taken that easy way out.
The process is underway.
Forget about the criminal process for your maintenance.
कौन तुम्हारे काम फोटोज पड़का
We have given you liberty to correct the order.
Correct your order, come to us again in this proceeding.
Item 9.
Lord, I'm seeking a passover on behalf of the respondent.
Well, let's may I just make it the petitioner.
And
But this is Passover, she wants, you're on KB, oh, you're on KB?
Yes, my lord.
Let it first start, let's see what he has to say, if we need your assistance, we'll pass it over.
First, there's a delay of 219 days.
Can you explain that?
Well, the real point is this, Malas.
No, why the delay, why the
Have
delay?
given me a loan.
Why the delay,
Well, as we went before the divisional bench, the appeal is actually not made.
14
Yes. Well, it's
minutes.
now, if your lordships will see pages 19, 20, the story is this. What he puts forth, he gave me a cash, a
Right.
loan in cash of 4.5 crores. The learned single judge does not believe this.
And
You
you claim to have returned, out of that, you don't claim the amount, but claim for, you returned a cash of what, 50 lakhs?
50 to 60 lakhs is what I said.
Cash transaction.
Well, which is why the learned judge says at page 20 clause G, what is also important is that the alleged loan had been claimed by the plaintiff to have been given in cash to the defendant, therefore barring the documents in question, authenticity of which is disputed by the defendant, there is no other proof of such huge amount being extended as loan by the plaintiff. Having said this, my lords, now the documents in doubt are discussed by the learned judge. If your lordships will see clause E at page 19, because he had to satisfy that he has this money to give me as a loan. In order to show that, he says he had an equitable mortgage created, his father had created in favor of his brother. That deed was cancelled. The learned judge finds both documents to be dubious. At the same time, there is serious doubt on the alleged memorandum of equitable mortgage and the deed of cancellation based on the stamp of notary that these documents bear, and the very nature of the transaction wherein again the amount is supposed to have been extended in cash by the uncle of the plaintiff to the father of the plaintiff, and thereafter the equitable amount cancelled. This is important. The documents bear the stamp of the notary, which on one page gives the expiry date of the license as 3/6/2019, while on the other page gives the date of expiry of license as 3/6/24. Consecutive pages. So the learned judge finds that the documents on the basis of which the claim is filed are fabricated. The judge finds there is no other proof, and yet page 35.
Counsel, let us not be hyper technical. He may be having a seal of, because this is exactly the same renewed for 5 years. So you use the wrong seal, the old seal, and then on the back also that correct seal. So the renewal is 3 that is the 5 years it is.
No, it's a document dated 2016.
What is his seal? Bear the stamp of the notary, which on one day expiry of his license, the notary license.
I know, the lordships are
Notary
free.
license.
First stamp is alright. Second stamp is a 2016 document. A 2016 document can't have a seal which says 2024 license expires.
This document is written.
2016. That is where the problem is. Read by the learned single judge. So the single judge rightly says.
Where is the document? It is
Let me have it.
No, is it?
No, that because of that dim pages and all, my learned friends. Now let's ask you to deposit the entire amount of 4.5 crores on these kind of documents.
What is your defense besides the technicalities? Because you have been having transactions.
No, this is not a technical.
And you agree that 50 lakhs.
4 crores 4 crores 50 lakhs cash.
50 lakhs.
That itself an extraordinary claim, Malaks. It's an extraordinary claim of 4 crores 50 lakhs.
Actually, that even your 40 to 50 lakhs transaction.
No,
cash.
which is why I'm saying
So how is
the
it?
test,
It's not
as far as as far as plea for a summary judgment, this will have to go for a trial. All I'm saying is, for a summary judgment to say,
What happened to the 138 proceedings, by the way?
Those are pending.
they are on, my lords. There he claims he gave me a friendly loan. In fact, that was why the first half of the judgment is a discussion on whether a friendly loan qualifies as commercial dispute.
It's a case where you both need to put your heads together and exchange some more cash.
Very well. My lords, we are prepared to go in for it. If your lordship so feels, we'll stick.
Both of your necks is on the block.
Please,
It's penultimate
Both
balance.
of you are brothers. Both of you are brothers.
no, we are not related. On this side, the plaintiff side, he says,
To be calling before a Kohli bench.
we are prepared to go in for a mediation. We are prepared to-
Yes,
Milord's already gone through mediation in the 138 proceedings multiple times.
you don't think that he will cough up any money, or you don't want the amount?
I want the money, but I know he will not cough it up. That's my concern.
No.
We've done it
What is
twice
the
and
kind of amount that he had.
He's not offered anything. He's not offered anything. Problem is he also has criminal antecedents. He has multiple FIRs.
So you should have known who you were lending money to. That's your problem.
Yes.
You created it for yourself.
I don't discuss it. Now the only thing today the court has said is to deposit it in court. It's not coming to me.
We understand.
That's
but
all.
perhaps we were.
But why the full amount for? When you are itself your claim is under some sort of a cloud.
Some doubt. There are
It's not a very clean claim.
So we are saying.
Some doubt has been, and bona fide doubt has been raised.
Instructions and also give me.
Oh, you asked for a password. We're giving you a password. Come back with instructions.
I'll come back.
We'll keep this as it is.
Okay.
Afterward.
Uplay.
And you want to come, Mr. Munizar?
Please let's have this
No, because you were in this 50 lakhs. That means
There's
4.5 crores will not be very difficult for us to believe.
Concern but also even if I enter into a settlement with him, he has gone to jail multiple times in multiple cases after getting into settlement with the other person.
That.
So what? You get your money. How are you bothered where he is in jail or outside?
He's before the final court.
Please, my lords.
He'll act with some caution.
Definitely, right? Please, my lords.
Both of you come with instructions.
It's Maya. It's the 3 lakh is the least of our concern.
Whereas the issue is
Some compensation.
well, the lump sum, the amount of lump sum compensation in this matter is least of our concerns.
What is
But the issue is the questions of law. The question whether postal department and therefore a public utility is in industry,
Such a matter earlier.
that has been referred to a larger bench.
Could you just point it?
I mean, JDC,
Just point out.
I'll give a citation. That, 2017, 3 SEC, 311. Well, it's that. Well, it's Willie Hogan, George Khayyam,
2017.
17, 3 SEC, 311. Well, it's will recollect, we relied on George Khayyam. The court relies on Bangalore water supply. And as to whether public utilities are,
Yes.
that would come under industry. And well, now it has been referred to a 9 judges.
Page, which page are we?
311 minutes. It's a short order. Because I think it was listed at some point.
So this was referred to a 9 judges bench.
Yes, please.
Now what happened in the 9 judges bench?
Because it's pending.
No, but Mr. Banerjee, suppose you just show us that what were the rules with regard to this engagement on temporary basis. Let us see. If it is because you may have a point. We may, but let us see the language.
Well, there are
What?
two aspects on one aspect. What we have said, our argument on temporary basis is this, that we have continuously cited Uma Devi. The court also refers to Uma Devi, where we are saying that Uma Devi puts a bar on this sort of temporary service being that he was there, and there's an admission which is recorded by the industrial tribunal, which says very clearly that he was there, he was employed whenever someone went on vacation. That was the nature of it.
Otherwise, he was where?
Otherwise, he was unemployed. So whenever someone went on vacation,
Exactly. That is why the query was made to you, that whether by any stretch we can bring it in Uma Devi. If that is the question, then he may not even have that benefit, because that benefit itself is very important thing.
that's also
You are right, but then we have to see the language. What is the rule pertaining to, suppose it was temporary, without any process, straight away you come and then you have a better case.
on the day.
No, but whether any process was gone into for even for that temporary engagement or no, just straight away discussion. You come.
No process.
That is why then you show the rule. What the rules required and how you have discharged that.
Just show facts, other facts that are there on the
Well,
judgment.
From this,
Pointing right on
it comes
facts.
page 43 of the tribunal order 45 minutes.
43.
Well, we'll start from 42, last page.
Yes.
Employer filed defense statement. It is submitted by the employer who was engaged in leave period of various permanent duty officials by senior postmaster Babudara. So whenever there's a leave period, he's in.
But how was he appointed?
It is here. It is when they leave such staff, join the delay, hence the workman cannot be continued against the same pay.
Right?
He was not regularly appointed.
Yes, he was not.
We said that he was the vacancy against which he was
Even for permanent engagement, there must be some procedure prescribed. If you are permitted to have a temporary engagement, then there must be something relating to that.
Well,
It cannot be that wide a discussion. You will pick up anybody on the road and then you say, come and work.
It is again stated that he was engaged on short-term periods. When the leave was over, such staff will be continued. That was a contract of specific short-term leave period. It was also employed that the workman was not recruited through departmental due procedure. He was not regularly employed and therefore there's no provision to do so.
So what was the due procedure required?
So were you supposed to, in ordinary course, issue an advertisement or tell the
Well,
employer?
if there was vacancy, obviously we would have to go through that process.
What kind of?
Well, it was,
So what did you do? Just somebody knew somebody within the department and got him on?
it
Was
seems
it like that?
It seems like. It seems like. Well, this is a group D post, Manoj. This is a group D post. This is not a.
That we will not like to interfere. We will say that this is without prejudice to the pending.
Leave the
Points of law.
leave the point out.
Point say that we are not
The 3 lakh lump sum.
As it is only lump sum fee.
Whereas in the present petition, condone the same is dismissed. However, the case to the petition is kept
Manoj will-
open for a decision in an appropriate case.
Manoj will condone the delay.
We will condone. Why not you
Condone.
Right.
Yes.
So the family court granted restricted conjugal right to the wife and dismissed his divorce petition on the ground that after the divorce was filed in 2013, main ground was in a revision under 125 before the High Court in 2015, he admitted I was willing to take my wife and daughter to my home. That is recorded and that by the court completely. Please turn to page 122. Paragraph 137.
Page?
120.
टाइम लगेगा
Yes,
12
para.
बजे के बाद
Paragraph 137. The first part of that allegation, he said they not made up. And in case there is a mention about subsequent acts, these were not included in the reply to the application under being filed by amendment. The applicant has not filed a reply application filed by non-applicants on so and so, and there is no mention about the subsequent events, all regarding on which the High Court is relied regarding poetry. And this established in CRPC against the Avinash is also pending in this court. The order has been passed under 125 CR. The order was challenged by the applicant. Also being criminal revision number 7 so 15, the applicant also admitted the fact in para 68 of his cross-examination. Paragraph 138.
Where is that? 158.
Page 121.
This is judgment of judgment dated 11.
Family court.
Yes. 138.
Now he said, may I read it again? Being honored to file an application under 125 CRPC and the applicant Avinash is also pending in this court. The order has been under section 125 CRPC. This order was challenged by applicant Avinash before the Honorable High Court in Jabalpur, being criminal revision number 2015. The applicant has also admitted the aforesaid fact in para 68 of his examination. The applicant in the same para has also admitted that para 11E of the petition is correctly mentioned that he is agreeable to his wife and daughter along with him, and the reasons mentioned in para 11 is correct.
Nothing across the board.
Exactly the same he had mentioned there. And everything started when the daughter was born.
Conduct or blaming him for being a drunkard, a womanizer, a person of loose character.
All these facts are not mentioned in the divorce petition. That's what the court says.
But court,
After that,
we should keep our eyes shut also to it.
absolutely.
I should keep my eyes shut to it. I should after that.
All those he accepts that I
Don't
will
deny them.
right back.
You don't deny there were allegations of these kind you made.
We have denied it. We have denied it.
denied that there were allegations of
Because the court did not believe, because they said these after fact, these have not been mentioned.
separated for the past, right?
That's why we want to go back. The daughter is young, and it started when the daughter was born. Everything was all right till then.
Daughter was born.
When he leaves the daughter and wife to the parents' house,
Yes.
how would the wife file a restitution application? And he admits, I want to take my wife back after the filing of the divorce petition.
What do you have to say about
Lord,
reconsideration?
she is willing on the paper. She never come to my house. Lord. In last 12 years, Lord, she has made a numerous complaints before the court, Highcourt, that the Vigilance Department, number of writ petition, why not action has been taken. I have been humiliated before the district court in Raipur. I have got the transfer to the court of Bilaspur. Even thereafter, she is taking 75,000. None of this, everywhere, but she has made frivolous allegation, number of writ petition, number of petitions they have filed.
Complaint to your employer, the court also contains allegations of your being a womanizer and a drunkard.
And
Are they? Yes,
No,
don't
Mother, even
If
after
it is not there, then you are on the back foot.
Mother-
You're saying no without hearing us.
Mother,
What did we say?
Mother,
What did we say? Please tell us. What did we ask you?
about womanizer and all these
Did
allegations.
she make any allegation in the complaint?
No, I had never made. My wife has made against
And
me.
ultimately, before the
I'm
court,
asking you, did she? Are you
Yes,
sure?
Mother, she
Are
has,
you she?
Mother, she has made.
So you said no. That's
Otherwise, I could not understand your
When we are asking you,
I'm-
did she make a complaint? You said
I'm
no.
apologizing for that, Mother. She has made a complaint against me.
That's what we asked.
which forum?
Towards District High Court Vigilance Department, judicial officer, Mother,
Very well.
had made the
How are
complaint.
you denying making such complaints and a series of them to
I personally feel that seems if that is said, the wife is contrite enough, that's why she filed it. And whatever,
jeopardizing his career or two?
he accepts, I want to take my wife back to the thing.
With this kind of.
That is after the
Why
complaint.
should we endorse your behavior? Why should we endorse your behavior? This kind of a
He
conduct.
himself has can't pardon that behavior. After 2 years of divorce petition, he himself has pardoned that behavior and is willing to take his wife and daughter back. Daughter is young, 12-year-old now. And the whole thing
Hey,
started,
counsel, how did you make the statement before the court?
he said
That you
so,
are
it
willing?
is written to me.
Maybe she was. Everybody has the right to reform, to correct, and I feel that.
Even thereafter, she has made writ petition revision.
Not after.
Even
Wow, please tell us, when you agreed to take her back, what happened after that?
no, Lord, she's never come to back. Thereafter, we have made around 75,000 maintenance, my Lord.
No, how do you say she has not come?
The
Well,
maintenance
She
is
never came to good number thereof.
how could she have come? She just landed up with her bag and the daughter to your doorstep.
Did you go to her
Yeah,
parents'
what do you
home with,
mean?
pick up the child and her and she refused to come? Did you go there or you wanted
No,
her
let's
to go every?
Even we are go there to Riva, my Lord.
Go there.
Even we have
When?
gone to
When?
Riva, my Lord.
When?
Lord,
After when you made that offer, when did you follow up?
my Lord, we are continue attending the court in Riva, my Lord. Every time we are going, my Lord.
Going to the court, please. We are asking you a simple question. Did you go to her home? You're saying you are willing to take her. She refused to go. Did you visit her parental home and say now the child and the wife accompany you?
Thereafter, they made a complaint against me.
Mr. Counsel, you filed the appeal.
My Lord, I had filed.
Why did you file the appeal after giving this undertaking before the court that you are ready?
At that time, we are willing to that family should be settled, my Lord.
After that, what happened?
Within
That is
1
the query of the court. What happened?
1 month. 11/7/18 is the order of the trial court. 13/8/18 you filed
And
it.
there the limitation, but she never come to my home, my Lord.
That is why you are never very.
Demonstrate in what manner for 1 month. What happened in that 1 month which was so critical that you filed an appeal instead of taking her and the child back?
She create nuisance and racket.
How did you?
All imaginary, all imaginary.
It's not an imaginary, my Lord.
All right.
Show us, show us.
In your
Right.
FA that you filed 1664-5 show us that you made these amendments. Show us.
No, that I was
If you
not.
didn't, then it's considered to be pure lies.
My Lord,
You file an appeal after agreeing to take her back and you don't utter a word about how you tried to comply with your undertaking and go and file, don't utter a word in the appeal, why will we believe you? Everything order.
my Lord,
You would have been on strong ground when you would have allowed her, and then you said, no. Again, you are back to your old ways. Enough is enough.
Special officer, you knew that these questions will be posed to you. You're not ignorant of law.
Millet C is also LLM Millet. Thereafter C has made with number of
You are the one who filed the appeal. She did.
She is desperate. And then you have condoned it finally, ultimately before the court.
But Millet, it's not only in word Millet.
Your words have not translated into action. Had it translated?
Issue notice. Counsel for respondent accepts notice. Counter affidavit be filed within 4 weeks to join it 2 weeks thereafter. Till further orders, operation of the interim judgment shall remain.
Millet, may I point to one thing? Millet, he is already married. Millet, Millet,
Married story is coming out.
married. Millet, and with adopted one daughter. Millet.
So you adopted a daughter?
In my
Your own
January,
biological daughter is there.
What?
Oh.
Cooling off period was over? Is the cooling off period over for
Millet, there is no feeling.
date of marriage?
That's the
Date of marriage?
date of marriage. Millet.
December 13th is the order of the court.
Yes, Millet.
When did you marry?
In 14th January. Millet.
Just wanted to that means everything was there. You are just wanting a ground.
Millet,
So the respondent
this
accepts
segment brought in
that
the
states
counter
that the
affidavit.
respondent
All will hear you.
states that the respondent has remarried on 14th or 13th or 12th of January.
14th January 20.
14th January 2024, so that the counter affidavit be filed within 4 weeks, you joined her 2 weeks thereafter. You also took your own sweet time.
They are aware, but in the after section we have 5 Millet.
We can
Let's start the service is complete. What would you save now? There's nothing to save.
The interim release is claimed in the meanwhile the
What? How will it help you?
official marriage.
How will it help you?
What interim relief? What interim relief? What interim relief?
Whenever we work on instructions, it comes from the side automatically.
But you can't automatically tell us, you know what the consequences of a remarriage is.
Item 12.
Yes?
Or it's the case of divorce by mutual consent.
So what are you doing here? We did not understand. We didn't understand what exactly are you looking at.
Your Lordship,
What are you looking at?
I am mainly now
Mutual consent, then you don't appear, then it's withdrawn, then you go back, you get it restored, then again there is a mutual consent. What is the word?
Madam, no withdrawn. My submission is that
You should be happy now there's a mutual
Your
consent.
Lordship, I'm that so far as divorce is concerned, my lord, I'm not questioning that part of the agreement.
What part?
I only wanted my visitation rights and rights as a father.
Get anything you want. There are terms of settlement, you put your pen on.
No, my lord, my rights as a father, they were
Your rights you decided to
You forgot
compromise.
about your rights.
Compromise your rights.
Madam,
That's your prerogative.
kindly tell you.
Go that way, we undo the divorce also. In a minute.
No, my lord, divorce, I don't.
Sorry, we will do
I
it.
don't want-
You're wanting and you're getting are two different things, counsel.
No,
You
no.
go that way and question your settlement, we undo the divorce.
Mother, I don't want, I'm making a statement, I don't want to undo the divorce.
You may
You
not
can't selectively go with the settlement.
want it, we will do it.
The settlement is a composite one.
Sorry.
It's a package.
Breakdown of marriage,
Parents dismiss.
It's a package. You have to go by the
Smart
settlement.
Your Lordship, kindly help me paid for, my lord.
terms of
Kindly help pay an except fee for,
most unacceptable conduct.
rather than my father, rights as a father.
You compromise them. Who told you?
Who told you to get into the settlement, set up a settlement?
Time.
My lord,
Somebody put a gun on your head and said, no, you please part company with your son.
that's why
You decided to compromise
Lordship, I am
with
submitting.
your eyes wide open.
No, my lord.
Eyes shut.
After 4 years of my recording my statement, the divorce by mutual consent is granted without recording my statement.
Consent, because you have accepted it. Don't go that way, counsel.
My
We
lord,
caution you.
I-
Moment you go that way, we will undo the divorce in a jiffy.
no, your lordship.
So don't go
I
that
am
way.
trying to see an extra fee 6 months. That's all.
Make your point.
Only one
Make your
paragraph.
point, please. What are you pointing out in that document?
But there, after 4 years, when the matter was referred to the family court, I made a statement that there are still some issues remain, and our statement may be recorded as required under section 13B of the Hindu Marriage Act.
All right, no merits dismissed. Next.
Then, my lord, I may be allowed
Thanks,
to,
madam.
I will then be allowed to seek my rights as a father. in
What
accordance-
is stopping you? Whatever you have under law.
We are not
Under
saying,
law. Why from our
we are
side?
not going to clarify anything for you.
It is your
Your
right.
comment is being smart by half.
Let him
Because
answer.
Lordship law says,
Please.
my lord,
Law says go. Who is stopping? I will stopping you from
the period of 18 months is the maximum.
Next, please.
Where the divorce is granted after
Again, you're on the divorce. Again, you're on the divorce.
My lord, I'm making a statement.
Don't make that statement. You're treading on a path which will take you to the end of a divorce being undone. So go that way and take the consequences.
Not even my petition, claiming only visitation rights. My visitation rights, my lord.
Sorry, you put your signatures on that document. You shouldn't have done it. Next.
Item 30.
Well, my lord, I may be allowed to withdraw it and.
After arguing like this, after arguing to the hilt,
My lord, I cannot question the divorce part of the agreement. But my rights as a father, if available under law, my lord, I may be allowed
Who's
to.
stopping you? If water is available, I will.
you have commented on your rights. Call the next man.
30.
But we are against an order, my lord. Interim protection was granted, my lord, by the appellate court. It did not allow the renewal.
Right. Already dismissed it.
My lord, I was just.
What you mean is storing without.
Allowing the truth.
Not
How
that.
can that?
But the point is protection.
How can that be the question?
My lord, that is not.
If it is the nature of the final relief you claim, then interim is documented.
Final relief will come.
Will it come?
In the nature of final relief, that is the relief you are back and you continue to service.
2000. No question. You were dismissed on 3/8/19. By virtue of a suit you choose to file in 2019, you want to put the clock back. That suit being decided. Look at it.
It's not like that. No. The moment there is an order, the first opportunity I come to the court, I request the court to grant me interim protection. My lord, thank you.
The court has
Key assets.
discretion.
In dismissal cases, straight away interim cannot be putting you back.
Can you say?
What was the charges against you?
Well, the charge is that there were certain loans which were granted, were not granted in.
Oh. And then you come back in the position and start doing all that mischief again.
Because it's there, it's not that it's, the money has been lost, my lord. It is
Nothing
not.
less than crore and.
Anyway, nothing. All the
How it is not about the that's not the question, my lord. That is, but there is question of.
You are right. There is absolutely no question in this.
Period and all those things.
No merits. No, we are sorry. We can't get it.
Malad, the irreparable loss, my lord, cannot be complained because my lord, the trial court says that irreparable loss. There is no irreparable
Cannot
loss.
because what are you saying? If you allowed it that way, is it irreparable loss? What are you saying, counsel? In dismissal matter, is there any irreparable loss? If the court cannot do good?
Stigma he is facing, my lord, that is actually.
The irreparable loss is your extra evidence. That is irreparable. That is why you want to be in that post.
We are sorry.
It's for all those 20-25 years, there was nothing against.
Maybe they didn't discover it.
One incident is enough. One incident is enough to throw you out.
The only what comes to us is that they were granted under my guidance because he was the branch manager. Then they suddenly say that.
You somehow manage to get that repaid, but that does not absolve you of your conduct.
But my lord, it's the
Counsel, you argued. We are not inclined. It's not a case for an interim order. You were already dismissed. You'll have to wait for the verdict of the suit to be decided. But not the main suit.
the only question, my lord, it will impact us socially, my lord. That irreparable loss is, my lord, I am requesting.
That we are sorry.
Because this
That
irreparable,
we can't do that. We are sorry.
the premier
We are
presiding
so
officer.
sorry. That's not possible.
My lord.
Thank you. Yes, please.
Please, Lordship. But this is with respect, not just contrary to your ladyship judgment in Union of India versus Subrata Na, but the judgment of the High Court and of the Labour Court, they completely ignore the law, which is that you don't apply criminal. Look at the inquiry officer's finding. I've gone through the inquiry officer's finding from page 52 to 57. Your lordship will find it's one of the most meticulously analyzed. There's an admission, a signed admission by him, which he does not deny till the inquiry. There's a bus driver.
During the inquiry, did the security guard depose in your favor?
Yes, security guard deposes his evidence is completely
So ask the security guard.
Yes, if your lordships are kind enough just to come straight away to the security guard, that is at page 34.
Yes, please.
And what the trial court says is that he didn't make a spot panchnama. And that's only, just one thing, just keep in mind that the security guard on the same day gave a written statement detailing everything, number one.
Did he abide
Number
by
two, his workman gave a written statement signed.
to see? Did he renege the security guard from a statement?
Never.
Let's see.
Yes, page 34. Kindly come to the second para 34 on 2nd June.
Yes.
On 2nd June 2012, I was working in the third shift. On that day, I was working at the main gate. After the completion of the time of the shift, the bus number so and so was stopped on the gate. At the time of checking the bus, the delinquent was sleeping. On the bag was one bag was under his seat. Hence, I awakened Mr. Pawar and asked him, whose bag is this? Shirish Kumar told me it is his bag. He says this in his
Process, process.
yes. Cross-examination was on 2nd June. First, there's one para in the previous para about his previous working, etc. Not very material. 37. On 2nd June, I was in third shift. In second shift, Tanaji Dhane was on gate in second shift. It is true that it is not mentioned how many persons were in the bus. It is not mentioned in my report. Panchnama has not been drawn where the bag was found. It is true that description of the bag is not mentioned in the report and statement. He says it's his bag.
What is it?
He gives it in writing. I'm saying.
Judgment shall remain stated for a.
Yes,
Thank you.
Let's stay on proceeding because otherwise we'll have to need no evidence.
Get that operation of it. Judgment shall remain stated. Yes, please.
All I'm asking for is an opportunity to argue and cross-examine the complaint. Now, there are 3 ex-parte orders passed against me. First,
Why should we extend that privilege to you with your conduct?
yes, Muslim.
Thrice you lost your right.
You have been dragging your feet at every stage. You don't deserve any indulgence as a husband.
Because we come to page 45 is annexure P14.
Make your point.
Because we filed a mutual consent divorce petition.
Then what
It was
happened?
filed on
Then you
15
didn't appear.
2000.
Then you chose not to appear.
No, my marriage did not choose to. She appeared on 31st of May 2023.
Yes.
Second, the next date
Because
was
it
given for
was
second.
withdrawn.
No, Muslim, please say.
It was dismissed as withdrawn on
Lord,
the
please see
31st of
page
May.
51. The next day is 16th November.
Come to P16.
P16 is where she appears out of turn and withdraws it without
Why
notice
did
to
she
me.
make a statement that she wishes to withdraw? If she wishes to withdraw, that option is available to a party till the second motion.
Yes, Lord, I understand, but I was not given any notice whatsoever.
You did not get a notice, assuming for a moment, you were not given notice, assuming. And there was an error. Fact of the matter is, in a matrimonial relationship, one of the parties says, I gave a statement in the first motion, but I don't want to go further in the second motion. That gap in the hiatus between first and second motion is for parties to mull over their options and take a call. If she did, whether you were there or not, it wouldn't matter. One of them is not interested.
I'm not challenging that order.
Okay.
What I'm saying is that page 51, when the first motion was done.
So you are registering the divorce. Are you registering the divorce?
Absolutely not. We are resisting the divorce.
Why are you resisting the divorce having gone that way initially?
Ex-parte order passed.
Either on mutual consent.
Ex-parte order passed. Your divorce petition dismissed default. Same day you file application, restored. Again ex-parte.
That's how you.
Then it was about.
It is point to page 59. Page 51. Next date is 16th November.
Yes.
Then she withdraws it on 31st May.
Why?
And when she withdraws it on 31st May, on the very same day, the consent.
No, she withdraws her consent. She withdraws her consent for mutual divorce.
Yes.
She can always withdraw it. There's nothing to stop.
I
You
understand.
don't need to do that for
No,
a.
she wanted to fight and take a decision on merit, not mutual. Only the mutual part was withdrawn.
Maybe I'm not getting it properly. What I'm saying is, I am not on the side that she cannot withdraw. She can withdraw, no doubt about it. All I'm saying is, on 31st May, when the mutual consent was withdrawn by her, on the very same day, the contested divorce was also received.
Sorry.
And in the mutual consent, one of the
conduct
withdrawn case.
Spira's family code, you were proceeded ex parte not once, not twice, but thrice.
Yes.
19/8/21, 8/9/22, 31/5/23. This is how you were conducting
And the
this.
first two orders have been
What are you doing?
May I just say, even in so far as the second order is concerned, let me just have page 24 for a moment. On the very same day, the
Anyway, no purpose is going to be served. No purpose, no purpose. No purpose is.
Then I'm proceeding.
No purpose will be served divinity. It will be more acrimonious. The only thing is it will be only acrimonious. Otherwise, nothing.
Opportunity
On
because
the
of
31st May, why am I proceeding? Party, that's my understanding.
But you chose to go that way. Next. Yes, thank you.
Item 16, I'm seeking a password.
Like, transfer application was rejected.
The wife has
110 kilometers, you can also cover.
husband is attending the 498 proceeding at Penda Road. He can come.
All right, notice.
Give me a plate. I have already made his lordship. The respondent number 3, my lord, was transferred from X to Y on 18th of January 24, and 18 days later, my lord, he was transferred again. The respondent. To my place. To my place, and I was transferred, my lord, to the place that he was.
For how long did you occupy that position?
I had occupied,
Tenure of your appointment.
I had occupied my position for 2 years.
So that was the period normally, but for
It is the minimum period. It is the minimum period.
any time after 2 years, you could have been transferred.
That's correct, Millard. But here is a case, Millard, where, as far as respondent number 3 is concerned, we have been able to show that there were, Millard, only recommendations from, Millard, MP, MLA, and, Millard, based on those, Millard, recommendations, Millard, in 12 days, Millard, he is transferred again. Now, Millard, just see the order. Millard, the impugned order, Millard, when we went up on appeal,
Yes.
against the interim order, Millard, the court said, I am adjourning this matter till after the hearing of the main matter is over.
What happened with the main matter? That was 19.
No, it's not yet. It's pending now.
What is the next date?
The next date is 19th March or something. 18th March, Millard. Millard, just see one line, Millard, on page 3.
Yes, we've seen it. That's why we're.
This is this.
No, anybody appearing on the other side?
I beg to prefer respondent.
What is your stand?
Now, as far as I have taken charge, why the
You are the private respondent.
Yes.
No, have not.
No, Mr. Anand, only answer one query.
yes, Lord.
Was your case for transfer recommended by the MP and MLA or no? Yes or no? Then you are required to be proceeded against what to call a transfer. On that very ground only we'll interfere.
Because I understand. However, Lord,
We will not tolerate this interference.
prior to that,
Prior to that we are not concerned. The moment they come, why did you ask on that ground itself? And will open that you may be proceeded against for this misconduct.
Lord, sir, kindly see.
No, this has to end somewhere.
Advantage of your connections and
And
private strings.
we are lucky to have the case before us so that we are able to interfere and do something.
Lord, before the recommendation was made, Lord, in fact, I was already, Lord, proposed to be transferred to that very
So I
place.
think better.
Why did you get recommendation? You wanted to flout your connections.
Lord, I understand.
So you go back.
Lord, I understand.
Suffer the consequences.
Now, Lord, yes, Lord. Now, if you Lord, see,
Recommendation.
22 onwards.
मेरा हॉटस्पॉट पे बंद हो जाए
22.
चलते चलते
22 is the MP. And see the letter.
Yes, that's
So and so now posted in num size, had
छोड़ देता
excellent
हूँ,
track
हॉटस्पॉट पे
record
बंद
of
हो
performance as an
जाए
administrative head, and now he is willing to be posted in Pasigat. He has taken charge Millard on that date.
So he's there willing. He's as if
He is willing.
the system is obliging him that he is willing to go there.
The next page 23 is an evidence. Same thing.
so. Who's on KV?
yes,
Accepts notice. Not a.
on instruction.
May not be on KVL, but
Within 2 weeks to join the 3 weeks. In the meantime, it is directed that now, who's in position today?
Millard, we are. I have seen
Shall continue to function from the post
From
of
which he was transferred.
post from
we have already taken charge. Millard is where I am.
Not coming back. We restore a status of anti gift.
From the time being transferred.
Even if it is there, then it will be restored and status of anti.
Pasigat.
I don't know what post are you on?
Oh, I'm sorry.
SCRWD.
Superintending engineer.
Superior.
Yes.
The petitioner shall continue till further orders. Petitioner shall continue to discharge his duties as a superintending engineer at
No.
RWD.
You can have to do that.
the RWD.
RW.
RWD, Rural Works Department probably.
Yes.
Pasigat.
It's corrected. We are wrong. We don't want to make an error on the assignment.
Millard, the petitioner is now in Pasigat. The respondent number 3 is in Itanagar. They are proposed to
I'm
Millard.
not asking you.
Yes.
From the place where you were working earlier, what is your position there?
Superintending engineer.
Where?
Milord, RWC.
RWD.
RWC.
It's RWD, correct yourself, Mr.
Milord, page 21, Milord, I find. Petitioner, Superintending Engineer, RWC Pasighat, Rural Works Department, Pasighat.
And Superintendent
Page 21.
Engineer RWC Pasighat, Rural Works Department, shall continue to discharge his duty as
Milord, may I say one thing?
high and dry for some time.
No, Milord, I understand, but as factually, Milord, factually, I have already taken charge. It will not,
It'll amount.
it is fine, not
No,
on that.
no. It'll amount to that. We say that he will be there. What the government does, that they do. We have a very strong connection. The government will accommodate you somewhere. We are not bothered about it. No, we are not bothered about you.
Say that you can
Go
discharge.
approach that MP again to get his posting for you. He stays where he was.
Milord, prior to that,
He stays where he was.
Please think at all levels
Yes,
political to get a posting, all on record. What do we do
Milord,
about that?
prior to that, in fact, prior to these recommendations, Milord, I was already.
So you took a step which you should not have been very
I
careful.
understand that should not have been done, Milord.
For the time.
Not have been, people suffer for the consequences.
Can't help it.
So you have to suffer for your consequences.
Yes.
As simple as that.
As far as he is concerned, he has already completed.
We'll see on the next day. That is why we should notice.
Sure, we are on the manner in which you entered that particular posting.
Milord, then Milord,
Absolutely shocking.
Yes, next.
then Milord, Milord, he has to, in any case, Milord, the government can transfer after 31st March.
Let us see,
We should not
deal with the government.
correspondence on the petition, on the petitioner taking necessary steps. Yeah, right? So let the others decide. Next.
Milord, the government has to look up. One and two are the government.
Yes, we told you to issue observe them. Next.
Lordship.
Milord, the making it returnable, Milord.
No.
Lordship, please.
19th we'll have to go to the Highcourt. This is an SLP and this you're coming through the route of the CBRC. You'll have to go to the Highcourt in terms of the judgment of this court. We'll give you liberty to approach the state High Court. Dispose it off. Yes. You are aware of the judgment, aren't you? You're not aware of that. That one.
Wait, please, Milord. Milord, there is same, my lord, granted relief, my lord, the old pension scheme, in a case where the writ petitioner bearing my lord, appointed in the year 2004. But the recruitment process started in 2021. I can produce the judgment, my lord. The High Court said, the recruitment process started 2021, will delay the respondent government will delay the appointment order issue. So the benefit should go. My lord, I appointed in that particular period, my lord. Only I joined in 3-4 days late, my lord. That is the reason, my lord, that I am not granted
What was
release.
your joining?
My lord, my joining, my lord, my appointment, my lord,
Your appointment was 26th of March.
26-3, my lord. My joining 1-4, my lord. 2003, my lord. The date, my lord.
According to them, your appointment was 1/4/2023. Show us the.
No, my lord. I joined.
Show us document. That's their version. Show us the stand of the respondent.
My lord.
1/4/2003.
1/4/2003, I joined.
No.
I'll counter.
Can we explain that, by the way? You're coming straight on merits.
18, 19, and refiling also 252.
Filing period, filing
plus
delay is there, my lord. Delay is there because
Explain it. Delay is all very well. You're not
Delay-
state. You are a private.
delay is there, my lord, because I approached the reason is that my lord, I approached a local lawyer. The lawyer took time.
That version doesn't engage us.
That is the real reason.
Coming on merits, completely overlooking the fact that
This, I think,
on the ruling because you have come with a delay of almost 1900 days. It's long enough.
I agree, my lord, because this delay, my lord, nobody prejudiced my lord, only I,
Delay.
my rights only deprived, my lord.
Condone the refiling, but dismiss on main filing. Next.
My lord, then I may withdraw this, my lord, I can take my remedy somewhere else, my lord.
What remedy?
Well, because my right is because my similarly appointed person already getting benefits, my lord. I can approach the chair and
Withdraw the present petition while reserving his right to approach the respondents for appropriate, take relief against the respondents before the, by filing.
चर्चा करेंगे इधर वो जाके ढोल झाल कर वो नहीं
recourse against the respondents as may be available. As paid for is granted, petition is dismissed. Yes.
हाँ 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 पेज रोकना पाले तो दे दो
Yes, Sir. By appearing after the petitioner,
Yes.
I am ready to place the judgment of the Patna High Court.
Let's see the last order just to give us a recall. Give us a recall.
Sorry, Your Lordship.
Let's give it.
Your Lordship had recorded my age criteria place to, I was asked to place on record the judgment of Patna High Court by which the only category that was changed was the academic qualification. Rest all the other categories of appointment remained the same.
Let's see that.
Yes. Your Lordship has D1.
That amendment of clause 8. Right?
Yes, Your
Of
Lordship.
the revised guidelines. D1.
Which is page number?
It's the last document. Additional application. Yes.
Paragraph 3, Your Lordship, of the judgment.
Okay.
May I read it, Your Lordship? Taking into consideration the aforesaid fact, we are of the view now the eligibility criteria laid down by the state government requires to be modified in a sense that persons with intermediate qualification and having diploma in education or B.ed from recognized institutions will be appointed first, and in case of there being non-availability, persons having minimum qualifications of intermediate, bracket class 12, should be appointed as para-teachers, and thereafter efforts should be made to train them as provided in the letter. Accordingly, that according to by the state government be published in terms of the order passed by this court.
Right. Then we turn to the next page.
No, Your Lordship. Now we come to the previous additional document that we had filed. Annexure D2.
Yes, the next, not previous, the next one. Translated copy of D2 and
Your Lordship, that is a different argument that I'll address at the end.
where D2? Earlier one.
Earlier one.
1245, but that's a Hindi one.
Sorry, Your Lordship.
Are you referring to the one at page 8 of your earlier additional
Yes, Your Lordship. The translated
Counsel,
copy.
if you are referring to the annexure 6, it came 2 years after your selection process happened.
No, Your Lordship.
Your is 2004 transaction?
Yes, Your Lordship.
This annexure 6 which you have filed with your annexure document, which is dated 1/7/2006. And the Highcourt order is also sometime after your advocacy.
The appointment.
Then they told to do something prospectively. It cannot date back to a transaction.
Process was stayed. The appointment process was stayed in the year 2004, and post the judgment of the Patna High Court, the appointment process happened.
Where is it that?
Your Lordship, annexure D.
Establish that.
Sorry, Your Lordship.
How do you show that?
Yes, Your Lordship. Annexure D of the previous edition
Yes, me
document.
too, the typed version at
Yes,
page
Your
6.
Page 9, Your Lordship.
9. Okay, page 9.
I'm reading amendment in clause 8 of guidelines revised for employment of Panchayat Shikshamitra bracket on contract. A guideline for employment of Gram Panchayat Shikshamitra was issued by the state government through resolution 336 dated 21/6/2002, which was duly amended, issued as revised advisory by resolution.
No, where is it?
पहले वाला है additional affidavit page 9. इससे पहले additional affidavit जो last where annexure D1 or D2 है D2 पर गए page number 9.
Yes.
Your Lordship has that. In light of the final order by the High Court of Patna in writ petition 12248 of 2004, regarding the process of appointment of Panchayat Shikshamitra, the state government issued further resolution 845 dated 7/4/2005 after amending clause 8 in resolution 1458 dated 11/8/2004 in the below mentioned manner. So, Your Lordship, the only criteria that was
When did you apply?
I applied on 21/9/2004.
1/9/2004.
Yes, Your Lordship.
Yes.
Very good. So
my age eligibility criteria was to be followed, that on 1/1/2004, I should be more than 18 years and less than 30 years. My age eligibility criteria was I was 29 years and 6 months old.
Cut-off date was 1/1.
1/1/2004.
So where is the age?
So
Where is the age now?
you have been non-suited, that private respondent was directed to be reinstated. You've been ousted?
Yes, Your Lordship, I've been ousted.
So you are as a consequence of the seat becoming vacant
On the
due to
previous
unsuitability
respondent.
or removal of the respondent.
Your Lordship, I was appointed in the year 2005.
On what basis? Because the other person was not appointed.
No, I was appointed. I was the first person who was appointed to this post.
Why have you been unsuited?
Because, Your Lordship, the Patna Highcourt in the LPA has considered that my year of appointment was 2005, whereas the resolution that has been passed by the Bihar government, the 1458 of 2004, only wanted that on 1/1/2004 I should be less than 30 years old.
Where is that? On 1/1/2004.
That's what we are asking. Where is that?
Where is that?
2004, you should be less than 30 years. Can you show any?
In extra D1 of the previous additional document that you have filed with us.
When you file annexures like this, you shouldn't number them in the same manner. Now you have two additional affidavits, both have D1, D2. That's the conclusion for future evidence. Okay. Yes, D1 of the earlier affidavit, right?
Earlier affidavit.
Yes, show us that.
Yes, Your Lordship. The translated copy is at page 6.
Yes, please. Yes.
The note, Your Lordship, below, where it is highlighted.
Age of the candidate.
The age of the candidate.
So this is not in dispute that the appointments were made pursuant to this very advertisement.
Yes, Your Lordship. This is not in dispute.
Take down that counsel for the petitioner has complied with the order passed on 5/2/2024 by placing on record the relevant documents. We have produced the documents, issue notice to the respondents on the petitioner taking necessary steps.
19 years.
Let's see.
Let's see what happens.
Let's see. They're not too sure.
Right.
23 orders, so.
Clarity.
Continue. Yes, is a lot.
Yes, petition.
What? If your lordship will see the last order of 23rd January, we have come out with a scheme, 23rd January.
So if we are correct, we had said that data entry officer works without any glitch and all. Make a category for giving them preference. Why just remove them?
What we have done, they will all be accommodated is our feeling. Just consider what we have done.
It should be 36.
Yes. First, your lordship's order was that at the request of senior counsel and learned advocate general appearing for the state of Odisha and other petitioners whose state government proposes to prepare a comprehensive policy to deal with regularization and adoption of data entry operators who have been serving since the year 2008, list on 1st March. First, Lord, I am conveying a request. The learned advocate general wanted to be here. He's down with a little fever, cough, cold, and he's not attending court at all. So he's not here. Now, secondly, Lord, now kindly see P36.
This is
what we have
done. Additional affidavit.
Yes. Application for permission to file additional document.
Yes, we have it.
All right. Now, this scheme is made. I'll just take your lordship through it. Lord. The first para is only formal that they were appointed, etc. Kindly have from serial number 1. Government, after careful consideration, has been pleased to formulate the following guidelines to consider regularization of data entry operator. The case of data entry operator for regularization shall be considered against 606 vacant posts of direct recruitment of junior revenue assistant, hereinafter referred to as JRA, under the R&DM department. This is revenue and department.
When your next advertisement is issued is what?
No, we'll do it. There's not.
One of them has been rejected by the High Court.
There's not a problem. There's not a problem on that, Lord. Recruitment shall be made in accordance with the recruitment rule. Requisition shall be filed. This will be done very quickly, Lord. We have all approvals. Only we have not made it formal, subject to your lordships having a look at it. Now, kindly see serial number 6 and 7. Rule 18 of 2019 rule gives power to the state government to relax any of the provisions of the rule if it is necessary. exercising powers of relaxation under Rule 18, state government shall relax the following provisions of the rules. Upper age limit shall be relaxed is first. Second, requirement of registering name in an employment exchange shall be relaxed. Third, minimum educational qualifications that he must have passed +3, which is graduation, that shall also be relaxed. However, he must be a matriculate. Then, my lord, in the total test is of 400. In addition, marks secured by them in the written competition, which is total 200 as Appendix 1. Data entry operator will be given extra weightage of 1.5 marks for every completed year of service, subject to a maximum of